This is an appeal in the matter of Aymes International Ltd and Nutrition4U B.V. and others.
Yes, Mr. Latimer, we've read your skeleton argument and we've read the judge's judgment.
Certainly, my lord, yes. Well, I won't go over old ground, as it were.
No.
Perhaps I can just bring the court up to date.
Yeah.
There isn't a lot to say in terms of the position of the three respondents. And essentially, nothing has changed since the permission to appeal stage. And as you'll know, the first respondent, the vendor of the shares, Nutrition4U, is now in a Dutch insolvency process described as bankruptcy, with the office holder being the bankruptcy trustee. And Mr. Vorst has said that he takes no part in the appeal. That's the first respondent, and that was aired originally at the permission to appeal stage. And the reason there's no one here for the second and third respondents is essentially the second respondent would have been controlled by Mr. Kettler up until the time of what's described as bankruptcy, and he lost his post as director on the commencement of the insolvency process. So in terms of representation, I suppose you could say that the first and second respondents go hand in hand. And now, in fairness to Mr. Kettler, the third respondent, although he's not represented and takes no part in the appeal directly, it's only right for me to draw two documents to your attention in the bundle. You may well
There's the letter he's written to the court.
There's the letter and a separate statement, yes.
Yes.
And essentially they set out his position.
Yes.
So while plainly I oppose or at least dispute a number of things he says, it's only fair at the outset that you know that they're there, and that's what he has to say. So, my lord, that concludes, as it were, just the preliminary of who's who. And if I may, I'll go directly to ground one, which is the construction point. Now, essentially, what you'll have seen is going to really the nub of ground one is this €150,000 a year, and whether it's included or, as the appellants say, excluded from relevant margin. That in turn sparks an inquiry as to what's relevant margin and what's included in turnover. And it may help just to look briefly at the agreement, which I've doubtless your lordships have seen.
We all noticed, incidentally, that although turnover is spelt with a capital T, it doesn't seem to be defined anywhere, and I don't think that the experts gave any real evidence about what it means in accountancy language.
Yeah, that's exactly it. And it's fair to say, I think all concerned have done that hunt for the definition of turnover exercise. It seems to be just a mistake of drafting. What it does mean, in my submission, is that turnover, whatever it is, isn't being used as a term of art in this agreement.
Right.
Because nobody's defined it, and none of the experts at least picked up on it to the extent where they recognised what the draftsman was doing and said, well, we can tell you what they mean by turnover.
But they don't even say that turnover is a term of art within the field of accountancy, e.g. for the purposes of preparing company accounts.
No, that's correct. The reality is whoever wrote the agreement either failed to, intended to, but failed to, or perhaps simply didn't realise that if they put turnover with a capital T, the reality is people will treat it as a defined term. That's really as far as I can take it, and I can't speculate as to what the draftsman thought they were doing.
No, indeed.
And what it does mean is that to some extent it frees the court from trying to find a definition that probably isn't there, to actually simply treating it as turnover, you might say, with a small t. But just going back to the agreement, if I may, there are only about 3 provisions which you probably need to look at initially. And in core bundle at page 173.
Yeah.
What you'll see is the beginning of the agreement itself. And over at 175, you see 2 recitals. They're mentioned in the judge's judgment, but I mention them now just as the starting point. Recital C tells us about option consideration. So in other words, not the payment for the shares under the option, but the consideration for the option. several years earlier. So C, the buyer wishes to have an exclusive right to exercise the option, not exercisable before the 1st of April 2020, and in consideration of the option, agrees to pay the company consideration of the equivalent of €150,000 in pounds per annum for the 3 years and 7 months, less the company margin on any order placed by the buyer before the date of the agreement and due to be delivered after the date of the agreement. And that defines for us the option consideration, in other words, the payment merely for that right to elect 4 years down the line. And in my submission, it's important because in defining that €150,000 very early on in the agreement, it's showing the parties, and the court looking objectively at what the parties intended, that €150,000 is payment for the option. It's not, as it were, a profit, a margin. And as I identify in the skeleton argument, the person to whom it would normally be paid, of course, is the vendor of the shares, the parent company, Nutrition4U. And it's only really by Nutrition4U's later decision to direct that the payments be made to Nutrimedical that, frankly, Nutrimedical sees any of the cash at all. And then in fairness, at recital D, also mentioned by the judge, the buyer, upon choosing to exercise the option, will issue shares in the buyer to the seller, such shares to have similar rights to those held by the buyer, based on the company value calculations and conditions set out in Schedule 1. So, for example, the seller of the shares, Nutrition4U, would never actually get cash. It would receive the cash for the option, but in return for the actual sale of the shares, it would receive shares in the appellant company. So that's recitals C and D. And then, if we may, look at page 182.
182.
Yes, thank you, my lord. That'll take you to clause 6.1.
Yeah.
And this really introduces, in the operative parts of the agreement, Schedule 1, subject to the completion of satisfactory due diligence. So just pausing there, all of this is subject to that, and that's reflected in the decree of specific performance itself. Subject to due diligence, including all financial due diligence, as above, the consideration payable for the option shares, so now a different consideration, shall be satisfied by the issue and allotment to the seller of such number of shares in the buyer as is determined pursuant to Schedule 1, or the fee of €1 if the company value as at the date of exercising the option is 0. And that's really the mechanism that the court was concerned with, that you're going to have to go through Schedule 1, work out company value, and that will tell you what happens next, whether it's a negative or a positive figure. And then,
just going back for a moment to clause 6.1.
Yes.
It says that the consideration is payable subject to completion of satisfactory due diligence. Is there some sort of an adjustment in the event of due diligence revealing nasties, or is it just that the buyer chooses not to exercise the option?
No, as I understand it, it's the latter, that the buyer would have simply make that decision prior to exercising the option.
Yeah. So subject to these various clauses has no legal effect, because if the buyer is not satisfied with due diligence, he just doesn't exercise the option.
I'm loath to say that something is redundant, because it's usually in for a purpose.
It only makes sense if the due diligence were happening between the decision to exercise the option and completion. And I haven't looked to see whether there could be in such an interval.
Well, there certainly will be an interval, but it won't be a big one, because the way the agreement works is there's the option notice. The transaction documents need to be provided very quickly, not quickly enough in the present case to stop a decree of specific performance, but certainly fairly quickly. So it may well be, as your lordship observes, that actually it didn't much matter.
Yeah.
That would take us directly to Schedule 1, which you'll see at page 193 of that bundle. If I may, rather than jump in with paragraph 1, could I invite you to look at paragraph 2, please, at page 193. Now, paragraph 2 gives everyone that, in a way, brutally simple formula for working out what company value is. And the good news, in a way, is that the only variable that the judge was concerned with in this court is relevant margin. The multiplier will always be 6 under the formula. Net assets were actually agreed at a given figure, which is mentioned in the judgment. So none of those actually matter for the court. It's solely relevant margin. And if I can just point out one thing, which may not have been appreciated initially at the case, is that in paragraph 2, the relevant margin multiplied by 6 plus or minus if negative net assets will be used to calculate company value. So if that relevant margin multiplied by 6 is actually a negative number, then in fact net assets are subtracted and you get an even greater negative number.
Which means that the formula underneath paragraph 2 is wrong. It should be plus or minus depending on...
It should. It's an assumption. All I could say, without speculating, is it's an assumption by the draftsman that this is a transaction that will be going ahead. But your lordship's right, that it's not a perfect formula.
But in a way, the points I'm making, I think, help you, because this is not an agreement whose terms are so clear that only one conclusion is possible.
No, that's true. The reality is that it's an imperfectly worded agreement, in the sense that it's workable with only the need for some assistance from the court. And what I'm trying to be clear about is I'm not presenting it, if you like, as a badly written agreement, rather one which simply leaves some questions unanswered. As your lordship observes, there are some bits which simply need to be corrected, really, by interpretation rather than anything more dramatic. So that's paragraph 2. And then that leads us on logically, if the only variable is relevant margin, paragraph 1 tells us what relevant margin is. And if I may just pause there. In my submission, the clue is almost in the description, relevant margin, because the implication is that there's some profit margin which is rendered irrelevant. There's something going to be left out of account. Otherwise, why not just call it margin? So what your lordships will see in paragraph 1, it's a slightly unusual paragraph, because often draftsmen will have a narrative form of what they want the calculation to be, or they'll give you a little bit of arithmetic. And actually here they seem to have done both. And in fairness, the decision makers on each side, not necessarily the draftsman, but of course the decision makers are 2 Dutch businessmen, actually entering into an agreement in a second language, English, which I must say both of them spoke proficiently at trial. There was no need for an interpreter, not even close to a need. But that may explain, as it were, one reason why they're using a formula. But what you'll see in my submission is, if we just look at the narrative version first, the relevant margin should be a sum equal to the turnover of the company, excluding any sales to the buyer, that's the appellant, minus the direct cost of goods, excluding those goods sold to the buyer, and any logistics costs. Then it goes on, sales and marketing costs, excluding those relating to new products, and €150,000 for the CEO's salary. Now just pausing there and to unpack it, as it were. In my submission, we know that relevant margin by its nature is going to have to exclude something else, what's deemed irrelevant. And in those opening 3 or 4 lines, the agreement is actually expressing what is irrelevant. And it's actually told us that it'll, first of all, it's going to be in the, what's included is in the nature of turnover, which is why my points about recital C telling you what the option consideration is a capital payment for shares, perhaps made by instalments each year, but is it a capital payment for shares, or is it more in the nature of turnover? And then just following this through at paragraph 1 of Schedule 1, we look at the series of exclusions from that. Any sales to the buyer, the costs of those sales, and so on. And so essentially the appellant has two arguments. The first is that the sales to the appellant aren't turnover to begin with. As I say, it's more in the nature of payments for shares. It's just good fortune that Nutrimedical got the cash and that its parent company was willing to direct that it got the cash. But the backup argument is that if it must be included in turnover, whatever that is, and then you strip out sales and the costs of sales and so forth, always stripping out what's due to the buyer. And what, in my submission, the draftsman was doing, or rather the parties were agreeing, is a situation that you'd look at the relevant margin in order to calculate company value, because it was the relevant margin that Aymes International Ltd would be paying for. And this is important because, of course, if you look to the past too much, you're actually bumping up relevant margin and therefore company value, even though the economic benefit of that will have been enjoyed by the shareholders such as Nutrition4U. They'll have enjoyed it in the past, but Aymes will be paying. And of course, if Aymes is actually buying into the company, it's not interested in the past, it's actually interested in the future. How much will this company be worth? What will it make? And that's why stripping out Aymes' own payments from relevant margin, in my submission, is really the only logical answer. Aymes wouldn't bump up its own price for want of a more elegant expression, only to pay even more. And it certainly wouldn't do it when it was never going to see that income stream again. Because if you think about it, if Aymes ends up being the parent company of Nutrimedical, it's not going to be paying Nutrimedical a profit. Or if it did, it would be a profit that would find its way back to the parent company sooner or later. It was actually paying for what Nutrimedical was worth, at least as far as Aymes International Ltd was concerned. And that's why Aymes wouldn't simply pay an inflated price in circumstances where it wasn't getting a return on the payment. And that, in my submission, goes to the heart of what the respondents were arguing at trial, and in my submission, and where the judge's construction is simply wrong because it overlooks that point. I'll come to the multiplier at the end, but that's almost the clincher, because of course the multiplier of 6 means that whatever calculation you do with relevant margin, the effects are increased quite dramatically.
And that sort of structure is a perfectly familiar one in the context of company valuations.
Yes.
You work out EBITDA or whatever and apply a multiplier, and then you take account of net assets.
It is. And there's nothing fundamentally wrong in it. But my submission is it's a warning sign for any judge construing relevant margin. Because you might say, if, say, it was a multiplier of 2, well, wasn't Aymes simply being generous? Was it even a bad bargain? My submission, once you get to multipliers of 6, which for a company purchase based on EBITDA would be potentially quite generous, but once you get to a multiplier of 6, the court might treat that, if not as a red light, then an amber light, that the court needs to be very clear about what goes into relevant margin, because the multiplier of 6 means that the effect of that will be quite dramatic, will be magnified on quite a scale. So that's Schedule 1 and how it's interpreted, those two ways. What goes into turnover to begin with? The alternative, put it into turnover, but strip sales out and costs of sales and so forth. But my submission in terms of what the judge has said about this is that although the judgment itself is clear what's in and out of turnover, in my submission, none of this is really addressed, as it were, head on in terms of explaining why all of this is wrong. And I'll come to the judgment in fairness to the trial judge to show you how it's reasoned through. Now, the reasoning itself begins at paragraph 110 of the judgment. If you have the core bundle, it'll be behind tab 8 if it's in paper form, page 128. Now, just so your lordships, as it were, can get your bearings.
Yeah.
Paragraph 110 is the section you may well have read
Yes.
about company value. But where it begins to, and the judge introduces matters, and in fairness, nobody can fault the judgment in terms of accurately identifying what was being argued. But the argument when it comes today will be that it's not that the judge hasn't very fairly set out what everyone's arguing, but really has indicated clearly what he agrees with, but doesn't really explain why the appellant is wrong. And again, to be realistic this morning, I have to accept that many construction arguments will be often a matter of not quite gut reaction, but a matter of impression. And just because someone doesn't articulate every last reason doesn't, of course, mean they haven't thought about it. That's a touch of realism for today. My submission is that despite all of that, the judgment effectively simply indicates very clearly that the judge is going one way without explaining why, what the defect is in the arguments advanced by the appellants. Now, paragraph 115, which you'll see at the top of page 130, here the judge starts, it's the defendant's case, that the option consideration was paid to Nutrimedical and not to Nutrition4U as the holder of the option shares, because it was being paid in lieu of profit margin. And rightly, the judge goes on to say that that was discussed at trial. And I've said in my skeleton argument for today that one of the dangers of the case is that everyone labels the €150,000, for example, as option consideration or as profit margin. And there is a middle ground in which it actually plays more than one role. Because, of course, what may be attractive to one businessman might be a lot less attractive to another. They each have their same reasons for wanting the €150,000 number, but they may look at it in different ways. So my reason for starting with the option consideration in recital C, that definition, is you can be sure beyond any doubt that that's what the parties expressed the 150,000 to be, nothing else. What you may accept, I'm not pressing it on you, but you might accept, is that there was a secondary role, and that was to give a margin, a profit, to Nutrimedical, so it wasn't supplying Aymes International Ltd at cost during the 3 years and 7 months or whatever of the option period. So the judge deals with that. And one thing I can deal with straight away is at the foot of paragraph 115.
Foot of page?
Sorry, page 130, my lord.
134, did you say?
Sorry, 130, 130.
130, yeah.
And you'll see paragraph 115. And 7 lines up from the foot of that paragraph. And the judge begins just after that italicized sentence. But again, there's no similar reference to option consideration. Mr. Bacon submits that any alternative construction would make no commercial sense. It would be double counting the express deduction of €150,000, which was neither what the parties intended or the call option agreed provides. The sum of €150,000 for CEO salary should be deducted from turnover, but the very same sum should not be deducted a second time, either as sales to AIL or for any other reason. Now, that's one point which is mentioned in the grounds of appeal and the skeleton argument, that the respondents had an argument that the €150,000 was being double counted, and that that's the reason it should be excluded from turnover. My submission is that's simply untenable. It's simply coincidence that you have more than one lot of €150,000 a year.
I haven't probably understood how one could take the alternative view, but obviously it was being argued that it was double counting. So how was it said to be double counting?
The easiest way to explain it is actually to look at Schedule 1, my lord. And you'll see that at page 193 of the bundle.
I quite follow. You get there, the 150,000 deduction in the calculation, so to speak, and there's a reference earlier on to 150,000 for CEO's salary.
Yes, and I suspect what's driving it is actually the mathematical formula. If you look at page 193,
Yeah, so that 150,000 is not attributed to anything.
it's not in the mathematical version.
No, it's attributed in the narrative, but not
Precisely.
In the,
So if you've read the narrative, the shorthand, as it were, arithmetical version would make perfect sense. But the point is, if you look at the formula without the narrative to precede it, that's when you could end up thinking there are there's one lot of 150,000, and that the appellant's trying to count it twice.
Well, the judge's account is acknowledged that 150,000 is for CEO salary.
Yes, it is. And in my submission, that's the mismatch. The judge understands what it's for, and then seems to be accepting an argument.
Not only that, he's here reciting the defendant's argument.
Yes.
And the way he presents it, the defendants themselves acknowledge that it's for the CEO's salary.
Yes, well, this was the point, that perhaps at trial, it was one of those points where the appellants, to some extent, are almost exasperated that anyone's saying that it's double counting. But in fairness, the respondents ran that point in all seriousness. And my submission is, if you read paragraph 1 of Schedule 1, you will have your answer.
Well, it's the old adage, once you get an impossible argument onto its feet, it's unstoppable.
Yes, yes. And indeed, that's pretty much what happened. So that's paragraph 115 and that element of so-called double counting. And then
the 150,000 which your client paid
yes,
was a fixed sum,
yes,
and that did not depend on any volume of sales which were made by the company to your client. They could have been millions and millions of pounds worth at cost,
yeah,
or nothing. The 150,000 would still be paid.
that's correct, my lord. That's the point in my skeleton, that they could be, I think I called it sales on an epic scale, or actually nothing. And it would still be due. And it was, that makes perfect sense in my submission. If you're actually primarily due to pay the parent company for an option, and you're later going to buy some shares, it makes no sense if you're actually saying it's in lieu of profit, because it may not be, there may be no profit for it to be in lieu of. And in my submission, it never was answered. You won't find an answer to that in the judgment. So if I may, going back to page 130, that deals with paragraph 15 and just one point that's mentioned there. And then there's, as I say, quite a very careful summary of what the arguments are, but you might also almost say that the decision, the punchline, as it were, is paragraph 118 at the foot of that page.
Yeah.
On this issue, I have no hesitation in preferring the submissions of Mr. Bacon to those of Mr. Latimer. For the reasons Mr. Bacon advances, I find that on the true construction of the call option agreement, and having regard to its language, its commercial purpose, the factual matrix and commercial common sense, the option consideration received by Nutrimedical in year 3 should be included within Nutrimedical's turnover. So just looking at, Lords, if we may, at those 4 factors, because it's open to any trial judge to indicate or to say that they agree with one party or another for the reasons given, and they're not required to elaborate once more. So it's not that sort of appeal. But if you look at those those four reasons, as it were, for accepting the respondent's arguments, looking at language, in my submission, that's what the court's already done so far. Just going back to the plain wording, plain as far as we can get it, of the agreement. And in my submission, there's nothing in there which really should cause anybody to simply adopt what the respondents were saying.
Well, doesn't the judge go on at paragraph 119 and 120
Yes, he does.
to expand on those points?
Yes, he does. What I was going to briefly do is just look at those four reasons and then go on to those paragraphs. Language we've done. The second of the four was commercial purpose. And we've already touched on that the €150,000 a year was actually consideration for the option. And what you've got, and it's important, in the agreement is clause 21.1. It's at tab 9, at page 191 of the bundle. What you'll see is clause 21.1. So no term of this agreement shall be enforceable by a third party, being any person other than the parties and their permitted successors and assignees. And of course, Nutrimedical isn't a party to the agreement. Mr. Kettler is, as an individual, because he'll be entitled to an employment contract. And of course, the vendor of the shares, Nutrition4U, must be as well. The point is that if anyone's coming along, and we're now looking at commercial purpose, and anyone comes along and says, well, that €150,000 a year has to be treated as turnover, and the answer is, well, turnover of whom? It certainly wasn't turnover of Nutrimedical, because it was actually being paid for something else, and was only paid, as I've indicated, because parent company says so. But crucially, Nutrimedical never has a claim on the money. In fact, any claim it might have is excluded. They go to the trouble of blocking a claim by Nutrimedical. Which is another quite strong indicator that whatever that sum was, it wasn't part of the turnover. The third of the judge's four reasons was factual matrix. But in my submission, that doesn't really add a lot more in isolation. Oddly enough, the background to what had gone on, there was a reasonable measure of agreement. There were some issues, they needn't trouble you today, about a meeting in Amsterdam in May 2019, where the two businessmen concerned were very much at odds about who'd said what. But that was 3 years after the agreement was entered into, so it can't affect the construction argument. The last of them was commercial common sense. And there are really 3 points to make on this very briefly. Firstly, I accept entirely that commercial common sense, it's long established that where there's a wording which is unclear, the courts can use that to help construe. I won't take you to Lammas, the authority, because the proposition I can't imagine is controversial. But the first, as it were, thing to be careful of is that commercial common sense used properly, in my submission, is where the court can actually see, is there a reasonable body of opinion, perhaps in a particular industry, or simply looking at the world at large to support a particular interpretation of commercial common sense. But it's an objective standard. You look outwards from the parties to the world around you. What it can't do is simply become a label that what I already agree with is duly labelled commercial common sense.
But there is a sense in which courts do that. Well, when looking at a clause, they don't say, is there a body of opinion out in the outside world? They say, well, this doesn't make sense.
Yes, certainly that's true. That's exactly what happens in the real world. But in my submission, what ought to happen is perhaps that first response then sparks a slightly wider look at perhaps what would the hypothetical reasonable person do, and so on. And if you look, I won't need to refer to the authorities bundle much, but if you have the authorities bundle, my lords, at tab 1, you see the decision of this court in Lamasa Investments and Synergy Bank. When you have that, they should all be paginated in the bottom right-hand corner, so it's page 9 of that bundle. What your lordships will see, there's a series of principles of contractual interpretation, which I'll spare your lordships me reading out. But the one that really matters for us in answer to your lordship's question, just over the page, there's a series of propositions, and it's Roman numeral paragraph 6. And if there are 2 possible constructions, the court's entitled to prefer the construction which is consistent with business common sense and to reject the other, rainy sky. But commercial common sense is relevant only to the extent of how matters would have been perceived by reasonable people in the position of the parties as at the date when the contract was made. And essentially it's that reference there. It would have been perceived by reasonable people. And that requires the court to go outside, as it were, an instinctive reaction of that can't be right, and actually resolve why can't it be right when you judge it by the yardstick of reasonable people. And it's interesting, and in my submission, no accident, that it's described as reasonable people. So you're not required to construct a reasonable man or anything of that nature. It's perhaps an inquiry at people more widely. Is there a body of opinion? I won't stretch that proposition really any further than it says.
How do you gauge whether there's a body of opinion without evidence? How is a judge going to do that? Particularly if you've got a contract in some specialist area. Well, what's he going to do?
I think your lordship must be right, actually. You can't. You could only do that with a body of, you could only judge what's a body of opinion if you go and get some evidence. Reasonable people seems to be more, is an objective standard.
Yeah.
But that will be the judge effectively having to put himself in the position of reasonable people. But what I'm trying to get at, possibly inelegantly, is what it isn't, is what may go on in the real world, of course, is that a judge sees something, says, well, that makes no sense, and therefore labels it as having a lack of commercial common sense. And perhaps that's what's gone on. And at a human level, one can understand why it might. So that's the submission on that point. And you've got the point about the multiplier and the quite dramatic effect.
That was your big point on commercial common sense. Why would your client pay this money and then have it inflated 6 times? That doesn't make a lot of sense.
No, that's exactly it.
I mean, elaborating on that a moment, I mean, going back to how companies are commonly valued in EBITDA. EBITDA is supposed to represent normally maintainable earnings.
Yes,
and you
as I
apply a
understand it.
multiplier to maintainable earnings to arrive at the company valuation. And you're saying, well, it's a matter of commercial common sense. These are not maintainable earnings. They're just sums that happen to be received by the company by way of option consideration.
That's it.
So it doesn't make sense to apply the multiplier to arrive at a valuation. But that's sort of an argument based on commercial sense without looking to a reasonable body of opinion or something.
Yes, but perhaps just so I don't get carried away, I'll step back from any mentions of reasonable body of opinion, because I suspect that's just not right. And it's actually, I won't put a gloss on the authority, which says reasonable people. And the judge, as in this case, as in so many, will have to form a view based on an experience of dealing with cases, what reasonable people would do. So that's the last of the judge's 4, language, commercial purpose, and commercial common sense. And if you just bear with me. Yes, that was the last of the four. And
Yeah.
where I've got to is just going back in that main core bundle to page 130
Mhm.
to 118. And
Yes.
as your lordship observed, paragraphs 119 and 120, the judge then goes further and actually gives a further set of or a greater set of reasons.
I thought he's elaborating on his points because 119 is the language,
Yes.
120 is commercial purpose. He goes back to factual matrix by looking at Mr. Ayrout's evidence. So I think that's an explanation of his headline point in 118, seems to me.
It is. And so in my submission, although the judge in a way has sort of gone back to some of the points and explained them in greater detail, there's a sense in which the judge is elaborating on what Mr. Bacon had said on behalf of the defendants, the argument there constructed. But the purpose of the appeal is to say it doesn't quite engage with it's not so much explaining why one side was right, but actually almost more important, to explain why the loser is wrong, the loser having to understand why they lost.
Yeah.
And at paragraph 119, if you just bear with me a moment, there's the point made in the last sentence of paragraph 119, the last couple of sentences. Although turnover is not one of the many terms expressly defined in the call option agreement, in paragraph 1 of Schedule 1, the parties have expressly specified various matters to be deducted from turnover, but notwithstanding that it is a defined term, there's no specific mention there of the option consideration. I view that as a significant omission. Had the parties intended that it should be deducted, I have no doubt they would have said so expressly, and not left it to be addressed by way of inference. Well, there are really 2 points with that. The first is that if it's not included in turnover to begin with, it doesn't matter. And the second, which is that if it is included in turnover and has to be stripped out, we can see the formula, the form of words in Schedule 1 will do that. And this point of if the parties had mentioned it, they'd have said so expressly. The problem with that, I think I described in the skeleton argument as a rhetorical device, is that you could say that about any part of any contract, and that you simply label it. Well, you could always have said a bit more about it. In my submission, it's not really a reason, it's almost an observation, but it's not a reason for reaching that particular decision, at least weighed in the balance against all of the other reasons which the appellant had advanced. For a
Your point, I think, is that in 119, the judge is assuming that the option consideration is part of turnover.
Yes.
Without explaining why.
Yes. That is the point, my lord, yes. And that's why paragraph 119 really betrays an error. And then 120, as you've observed, almost doubles back then, and we go to commercial purpose, which I've already dealt with. And if you I'll just leave that there. So, my lord, unless I can assist you, or my lords, unless I can assist you further, those deal with my submissions on ground 1 of the appeal, which is really the construction point.
Yes.
I wonder if you're content if I move on to grounds 2 and 3.
Yes.
Thank you. Now, grounds 2 and 3, in a way, it's tempting to take them together, but they're actually talking about different things. We move on from construction to some of the evidence that was admitted under ground 2, and then separately under ground 3 to how it's treated in the judgment. But before diving into it, The first question that your lordships may ask is, why did any of this much matter in a case about construction? Why did the court need to make findings? And in fairness, you might challenge me and say, why did the parties need to provide evidence anyway? Well, the short answer would be, firstly, some evidence about context will almost always be needed for construction of any agreement, because the danger of a minimalist approach is that the judge then can't see the context, and it's almost unfair to ask someone to construe the agreement in a vacuum. On the other hand, the danger of a bit too much evidence is that the parties get into issues of credibility and so on. But what should govern all of this and keep the trial on track, in my submission, is a very firm attention to what's relevant, to keep the factual evidence contained so that it's helpful, as opposed to actually sparking off inquiries into other matters. And my submission at the end will be that paragraphs 2 and 3 are almost a worked example of what happens if that first control, as it were, what is relevant, isn't applied quite rigorously. So
Well, did you object to the line of cross-examination? You objected to impeaching answers which you said went only to credit, but did you object to cross-examination about no ultra at all?
Yes.
You did.
And if your lordship wants to see that not only did I object, we've brought instead all of the transcripts, and they're not in the bundle, but in case anyone did need to look into it. If you just bear with me a moment. If you could look at the supplemental bundle, please, at page 305, you'll see my skeleton argument for trial.
Yeah.
And what you'll see at page 308, this is just to see how it's introduced. There's a brief section of who's giving evidence and so forth, which you'd expect. That's fair enough.
Sorry, where are you now?
Sorry.
Who's who?
308. That just introduces this topic of who
Yeah.
is giving evidence.
Yes.
And then if you look at page 309, now you can see it in context. This is what I'm writing for the appellant even before the trial has begun. I won't read it all out, but perhaps if your lordships would be good enough to look at that short section.
Yeah. Yes.
And the reason I'm raising it is because, of course, nobody's actually told anyone on the appellant's side that New Ultra is on its way. It's not pleaded as an issue, nor should it be, it's irrelevant. And there's no mention in Mr. Kettler's witness statement, because that would be a warning sign that he's going to introduce some evidence in chief about it. It's not mentioned there. And so it's actually, I think it's bundle D3, which appears with all of the other bundles. And that little section you've read was really in response to that, of effectively communicating to the respondents, well, we can see you coming and we're objecting to it. So the objection's taken at trial in relation to that. And the point is argued. And the judge mentions, actually in the judgment, where he says, Mr. Erout's evidence, Patrick Erout's evidence, is delayed for a couple of hours because there's some disclosure and he has to rule on matters and so forth. So the New Ultra objection is taken, and it's flagged up there, taken at the trial, and the judge concludes that some questions can be asked about it. And it's important in my submission just to be very clear why it matters, what New Ultra could or couldn't prove. None of this is pleaded. And if your lordships can bear with me for 2 or 3 minutes, I'll explain with the documents how it fits together. But I can assure you it won't be a long digression into somebody else's litigation many years ago. And the best way, just to explain it in user-friendly terms, is if you have that supplemental bundle, there are 3 very short judgments of the Irish High Court. if you have the supplemental bundle at page 279, what you'll see is this is actually a disclosure application. It's an interlocutory application in Ireland. And Mr. Justice Barrett explaining how it comes before him. This is all page 279. And he says that paragraph 1, Nutrimedical is a manufacturer of nutritional supplemental products. It has exclusive title to a particular trademark. It supplied them. And then following this is all paragraph 1, following the commencement of these proceedings, Nutrimedical licensed and assigned various marks to Aymes International. So that's how Nutrimedical and Aymes end up on the same team, as it were, in the Irish litigation. And then what look like trademark proceedings are issued in Ireland against this company, Newey. And then paragraph 3, when those are served, it appears that Newey responds, if you just bear with me. That's it. But paragraph 3, the proceedings are started. And then at 4, the judge says, without seeking to diminish the seriousness of the trademark dispute between the parties, it wouldn't be unfair to describe the facts as a fairly typical intellectual property dispute. And then he goes on to describe this particular behaviour. Effectively, there are 2 communications which Aymes the company, and I am not talking now about Mr. Aymes, the sole director and shareholder, Aymes International Ltd, that's one or more employees had been responsible for 2 communications, which had been described there as poison pen correspondence. Yeah. And that seems to have been what the respondents were interested in the present case. It was really showing that Aymes International Ltd, and again, I'm not talking about Roger Aymes, I mean the company, had been engaged in something discreditable.
Yeah.
And there's an important part which in a way would have been helpful if more attention had been paid to it in our trial. Just over the page at paragraph 8. The judge says, all of the above mentioned behaviour of Aymes International has had at least 2 consequences, and it's the second of them. And I won't read it aloud, but essentially the judge goes on to describe the behaviour that he's referring to, referring there to the authorship of the July 2014 email, and suggests that the court must bring more than a soupçon of scepticism when it comes to assessing the position and evidence of Aymes International. Even so, it's important that the court be careful not to draw the longbow in this regard. Our courts may be temples of truth, but few within them are saints.
It's a mixed metaphor, I'm afraid. I simply don't understand.
No. What it seems to be, though, in not drawing the longbow, seems to be in keeping a sense of perspective. And that would include, in my submission, distinguishing between the company. If you look at paragraph 8's beginning, he's only talking about the company and the individual. And the reason I go through that little digression, I appreciate it takes a couple of minutes, is that if it was being said in the present case that any of that trademark litigation had a role to play in construction of a commercial agreement in August 2016, the response would be it can't do. And these were events of 2014 and 2015, the correspondence the Irish judge was concerned with. So it can't really affect how you construe an agreement in a different context a couple of years later. Equally, there isn't a word of criticism of Roger Aymes, the individual there.
But it is his company.
It is his company. And so the issue at trial was, did he know one of his employees was doing this at the time, or does he find out later? And part of the complication is he issued an apology. And of course, Mr. Aymes' evidence is I did issue an apology, what managing directors sometimes have to do. The issue, which the respondents were pressing, was that he actually knew in advance and that he was in on it. Now, my response to this, both at trial and today, is actually that that's a finding on a completely collateral matter, which has no bearing on what we're dealing with, which is effectively some evidence to provide enough context to make an intelligent construction of the contract as at 2016. And in fairness, there was some other evidence because there was a damages claim which has fallen by the wayside and your lordships aren't concerned with. But at no stage does any of that really involve the sort of credibility questions about Mr. Aymes, where the judge would actually need to be reaching for evidence of character or propensity to tell the truth or otherwise.
Can I just understand this a bit more? Mr. Aymes' credit was relevant.
Well, it was relevant in the sense that there were some disputed issues of fact, yes.
So the judge isn't wrong to try to work out whether he's a reliable witness.
That's correct, yes.
When you are thinking about a witness's credit, you can put matters to him which you hope the judge will say something about it, even if you can't lead evidence on the subject.
Yes, certainly. Although perhaps the only safeguard I would say is that there's a difference between the rules of evidence and the professional duty of the advocate. The advocate's going to start putting allegations of dishonesty. You don't need evidence in chief, but you'd need a basis for what you're about to ask.
I mean, here, the judge thought that what he was referring to warranted a degree of scepticism in assessing the evidence of the company.
Yes.
Now, the same material could legitimately be thought to be something to suggest that the judge take evidence given by the individual with some scepticism.
Yes, well, the first point is that it's probably irrelevant to our case in the sense that we're dealing largely with these contractual matters. And so, your lordship's right, you can actually use almost anything to impugn someone's credibility. But there has to be some link between the matters you are putting to impugn credibility and what's going on in the case. And so, for example, if this was a case which turned on an oral agreement and absolutely central to the issues was, is anyone telling lies, then the court might well want to look at things which are actually at 1 or 2 or 3 removes from the particular case. In a case like this, where really the parties are having to set the scene for the judge, but can't tell him subjectively what they intended because that is irrelevant, in those circumstances, what will be relevant will actually be far more limited.
But if you are concerned with credit,
Yes.
I'm not sure that you say otherwise. Do you say it would be wrong? I don't know if it happened actually. Would not the cross-examiner have been entitled to put to Mr. Aymes his judgment?
Well, he could put the judgment to him, but the judgment doesn't say anything about Mr. Aymes.
But would he not be entitled to put the judgment and say, well, you must have known about this?
Yes, he could probably do that, as long as the question was, did you know, as opposed to, I'm alleging it was you knew, because he'd have no basis for that.
Well, he might have quite a lot of basis, because if the company did something and you're cross-examining the owner of the company, who is also the chief executive.
Yes, he's sole director and shareholder.
Then you might think there was quite a lot of basis for thinking that the individual would know about what was going on.
Well, you could. I accept. You could certainly put it. The real question then, and this is the ground of appeal, is that those answers to credit, of course, are normally final.
In the sense that you can't lead evidence to the contrary.
That's correct. Yes.
So are there then 2 questions? A, are you entitled to ask Mr. Errett about it?
Yes.
As did happen. B, leaving that on one side, going back to the jury cases, well, the jury, we're told you can't lead evidence to the contrary, but the jury doesn't have to believe what's said. So presumably the judge doesn't have to believe the answer either. But is then the second question, even supposing he doesn't really believe the answer, is he wrong to make a finding of fact about it?
Yes, well, this is why there isn't a one vast ground 2. It's separated into grounds 2 and 3. Because
Well,
one is
just a minute. If we go to your paragraph 5 in ground 2,
yes,
page 17 of the core bundle, the first point you make is that line of cross-examination was irrelevant. So the question, let's pick up my lord's point, the question shouldn't have been asked at all
yes,
because it wasn't relevant. The second point you make is that Mr. Aymes' answers that went to credit were final, therefore additional evidence should not have been led to contradict those answers. So
Yes.
that's a different point. And the third is that it was so peripheral that it wasn't worth examining those issues. And that really is a question of what? Case management, much as anything else?
yes. But just so I don't announce yes in an unqualified way, there's case management in the sense of when do you do disclosure or managing a difficult injunction application. And those are questions where there may just be no right or wrong answer. But in my submission here, it's more than case management in that managerial sense, although I have to accept it's a matter of discretion. And that third point should also build in, as I go on and say at paragraph 5, that the procedural safeguards you might expect were simply absent. And the danger of going ahead without the procedural safeguards is that you have a very lopsided presentation of the evidence, because Mr. Aymes is going into a witness box effectively to be cross-examined on his involvement in an old case, with no one telling him quite why they say he was involved, as opposed to what counsel may do, which is ask a few questions to see if it yields a fruitful answer and then see if you can take it a little further.
Now, that brings us back to the question you were asked about whether you'd objected, and you took us to your skeleton argument and showed that you did object,
Yes,
but I would assume it must follow that there was a ruling by the judge dismissing your objection.
yes, and you can. Yes, there is. I'm sure there is. And also in the.
Do we have that in the bundle?
No, we don't. If we needed, I'm sure we could find it because we brought the transcripts as a precaution. What you will see in the bundle, in the judgment, if you just bear with me, it starts. That's it. The findings complained of, if you just bear with me. There's paragraph 61, where the judge actually deals with New Ultra and says what his finding is. And then he disagrees with me. And then at 62, he introduces the evidence of Mr. Arrout.
Yeah. And then we've got a ruling, but we don't know what it is, on page 112.
That's it. And that was, when your lordship asked about, did I object to Mr. Aymes? I think the answer to that is yes. But I was just showing that I objected again when we got to Mr. Arrout, because that's a second objection, really for different reasons. Your lordships don't have that. And if you just bear with me. That was it. It's just after that.
And then at paragraph 65, the judge refers to your reliance on what's said in Phipson.
And that's really where that bit of it ends, my lord, yes. So essentially, what we could do, perhaps at the end of oral submissions, if you were willing to rise for a few minutes, we could get you the transcript of the objection and any ruling.
Yeah.
That if you needed to see that, that could be dealt with.
Just send it to us by email afterwards.
Certainly, my lord, yes. Certainly. But the reason I mentioned that just offhand was that there's an element of, it wasn't just, as it were, what you might call a sort of soft objection in the skeleton, and then it's quietly forgotten about. There's an objection at trial, and you can see there another one.
Yeah.
So just sort of breaking it down, as it were, there's a question of relevance, and in my submission, I'm driven to accept, as your lordship points out, that as a baseline of relevance, yes, almost anything's relevant to credibility. I think it's only fair to the appellant to say that relevance isn't, as it were, an absolute. It's usually, there are degrees of relevance. And it wasn't so central to what was going on, the best example being a furious dispute about what was said over an oral agreement, that it justified being labelled as relevant and coming in. And the second, and then there are the second and third points in the grounds of appeal, which your lordship's identified. If you just bear with me. That was it, that if he was asked about it at all, Mr. Aymes had given his answer. And in my submission, having given his answer, that really is the end of the matter.
I mean, do you come back to this thing I find a bit puzzling? Because if you go back to the jury type case, well, the jury doesn't have to believe it. But of course, it was never going to make a finding of fact about it.
No.
It does seem quite odd that a judge should be able to make a finding of fact about something in circumstances where it has just been put in cross-examination, no evidence should have been led on the subject, there's been no disclosure, blah, blah, blah. But at the same time, if the jury could disregard the answer and say, well, I think that suggests he's not a very truthful person, well, why shouldn't the judge disregard it?
Oh, well, there are two reasons. The first is that there are no real limits on what the jury can think about. There's a series of directions which they're bound to follow. None of us really know what will go on in the jury room. So if your lordship's describing what probably happened what happened in civil juries in the real world a long time ago, the answer would be absolutely. They did all of that and probably worse. But the fact is that's irrelevant. It's simply an observation about what probably went on.
Is it just an observation? I can't remember. When I looked at the case you put in the bundle,
Yes.
it seemed to be saying, well, that's legitimate. This is Hobbes, is it?
Yes, it's tab 3. And I think that the first section on the foot of it's the foot of internal page 18 of the report, or page 66 of the bundle, if that's a bit easier.
And if you go on to the next page,
That's it.
it's cross-examination as to credibility, commonly called cross-examination to credit. To permit this would involve the court in an interminable series of controversies, but I quite follow that. But then it says down the bottom, if the jury hearing the answers given by the witness do not believe him, they're entitled to do so, and to use the view thus obtained as to his credibility in rejecting answers. So it's not just, well, we don't know what goes on in the jury room. This seems to be what the jury is entitled to do, and therefore presumably what the judge now is entitled to do.
Yes, the short answer to that would be, that's obviously a generalisation. It's talking about matters in the abstract. And of course, what there should be, to make that truly accurate, would be to say that if they draw a conclusion against the credibility of the witness, then there has to be some basis for that, and it has to be relevant to what they're considering. So, for example, if you had material which was, supposing you had, it's hard to think of an example, supposing you had a business case, and like this one, and you were talking about matters relating to business done between Aymes International and Nutrimedical, you could see the obvious relevance and why a jury would be quite entitled to say, well, somebody didn't act well in a particular transaction in the past, and we draw an adverse inference against the defendant, against the witness. But supposing you got something quite separate, and just thinking aloud, you had evidence that somebody didn't play fairly at sport, and they weren't a very honourable sportsman, say. That would be so irrelevant to what was going on in the business context, where money was at stake and integrity was at stake, someone's word was at stake, and so on, that there you would say, well, the jury shouldn't, or indeed it should be stopped.
Can I take an extreme case? So suppose someone goes into the witness box, he's giving evidence. It's put to him in cross-examination, look, here's a certificate of conviction for an offence of fraud for which you were sent to prison for 5 years.
Yes.
And the chap says, no, it isn't. I didn't do it, it doesn't relate to me, blah, 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 blah. So what's the judge supposed to do with that?
Well, just take the certificate of conviction out of it for a moment. If somebody puts it to a witness that they have a criminal conviction, and the answer is no, I don't, then that's final, and that they can't call evidence to rebut it normally. What I would say is the example your lordship gave. Supposing they had introduced in evidence the certificate, there might be an issue then about whether evidence could be called to prove the certificate or something like that.
Can we just go back a moment? You posited that the witness is asked whether he has a criminal conviction, and he says no. But I think you also accepted, in answer to my Lord Justice Newey, that the judge is not required to believe the denial.
Yes.
But you also said, unless I'm mistaken, that in order for the judge to arrive at the conclusion that he doesn't believe the denial, there must be some material. Now, how does that work if you're not allowed to adduce any material to contradict the witness's answer?
Yes, well, if the judge says that, if the witness denies something, and that should be the end of the matter, and what the case seems to be saying is that the jury may disbelieve that denial and say, perhaps because of someone's demeanour or something of that nature, they just don't believe them. And they'd be directed how they could apply that disbelief in evaluating the rest of their evidence. I suppose if they do believe them, then it's a much shorter question, because the denial would simply stand.
But my Lord's point is that in this day and age, e.g. post-Guestman and other cases, we don't rely upon demeanour. And in any event, even if you leave demeanour out of the equation, we still have to give reasons.
Yes.
For our decisions.
Yes.
And how can you give a reason for disbelieving a witness's answer when there is nothing admissible to contradict
it? The disbelief then would actually have to come from some other source of evidence in the same case.
But ex-hypothesi on your argument, there is no other evidence.
Well, there would be, because, or there could be, because one of two things would happen. Either there's nothing else in the case, the judge is met with a denial, and that would be the end of it, because it's a matter going to credit, not the issues in the case. Or, for example, if someone had had 2 or 3 matters put to them, and the judge said, well, I might have been willing to give you the benefit of the doubt on the first denial, but the second one is pushing it, just in terms of what is credible, and perhaps the second or third one, the judge would be saying, I simply don't believe it. It's not all coincidence. You're not all wrongly being accused.
I think he'd be complaining the judge didn't give himself a Lucas direction.
Yes, there might be something in that. But the point would be that where matters of credit are concerned, so I'm not talking about the evidence on the issues actually in the case, there will come a point where the judge effectively has to say, I can't resolve it.
Yeah.
And that leads me into the claimant's case. which is also in the bundle, and I can deal with it shortly.
Yes, well, that's the judge coming up with theories of his own.
Yes, if you just bear with me. Yes, there are two cases. Firstly is claimant, and if you have it's page 39 of the bundle, of the authorities bundle. And the reason claimants matters at 77 is at Roman 2, it's explaining statements of case play a critical role in identifying the issues to be determined. And the point is none of this is pleaded.
Yeah, well, that goes to the relevance point, doesn't it?
Well, no, it's two things. It goes to the relevance point, but it also goes to the should the judge allow it as an exercise of discretion.
Oh, I see.
Because the more you stray from the pleadings, the more likely it is a judge will be not just within their rights, but also almost policing the case to say, no, you can't go there. And then at Roman 4, adherence to the issues that have been identified by the parties, particularly by the pleadings, prevents the trial from becoming a disorderly free-for-all. Now, the reason that's important is it's not identified by one of the parties or in which one of the parties is seriously interested. They're identified by the parties, and there's a set process for doing that. And it wasn't followed here. That's why claimants matter.
That sort of comes. You're not so constrained in what you can put in cross-examination to try to undermine credit. I mean, the fact that something is not ultimately relevant doesn't mean that you can't put it as something bearing on credit. But then one might become uneasy about the fact that the judge purports to make findings on the point.
Well, this is the sort of the ground 3, as it were, which is actually what do you do with it? And there's a mismatch in my submission between the judge's findings as to what he actually says about Mr. Aymes' character and the evidence that was available for that. And there's also a mismatch between, as it were, the strength of the language in which they were expressed, they weren't mild criticisms, and the evidence that was available for it. And there's one final, but before we put that bundle away, it may help, that the last of the cases is re W a child.
Yeah.
Again in this court, and it's page 146 of the bundle. In my submission, there are two things to be gained from these two paragraphs at page 146. At paragraph 95, where during the course of a hearing, it becomes clear to the parties and or the judge that adverse findings of significance outside the known parameters of the case may be made against a party or a witness, consideration should be given to the following: ensuring support of such adverse findings is adequately put to the relevant witnesses, if necessary by recalling them, prior to the case being put in cross-examination, providing disclosure of relevant court documents or other material to the witness, and allowing sufficient time for the witness to reflect. C, investigating the need for, and whether there's a need for adequate advice. That last one probably doesn't affect us. But these are the procedural safeguards. If it's not pleaded, for example, and it does crop up, what might the court be needing to do? And of course, what you're faced with in the present case, what Mr. Aymes is faced with, is simply his lawyer, me, has spotted something in a bundle thinking, I think I know where it's going. I think to the point I write about it in the skeleton before trial. There's an objection at trial. But essentially he's in the witness box, not quite knowing where all of this is going, except that someone's trying to impeach his credibility. And for example, there wouldn't be, or there isn't time then in the middle of cross-examination to start saying, well, shouldn't we look at company files? Shouldn't we find out, say from contemporaneous correspondence, who knew what, or something of that nature? And then 96 is the important bit for us, perhaps for your lordships. In the present case, once the judge came to form the view that significant adverse findings may well be made, and that these were outside the case as it had been put to the witnesses, he should have alerted the parties to the situation.
Doesn't apply here because these points had been put.
They've been.
You object to their relevance, and you object to the fact that impeaching evidence wasn't allowed when it shouldn't have been, you say. But nevertheless, the points were put.
They were put, albeit very briefly. And what I was going to
But in Re W, everything appeared like a bolt from the blue in the judge's judgment. That was the real complaint. Nobody had suggested that the social worker and the policeman were going to be criticised in this way. It all came out for the first time in the judgment.
Yes, but there are 2 points. The first is that I'm not trying to draw a factual analogy, it's just the principle. And the point I was getting to, as it were, at Muller, 96 was the important point. One option at that stage, of course, is for the judge to draw back from making the extraneous findings. And after due consideration, it remains a possibility that adverse findings may be made. The judge should have established a process which met the requirements. Now, I appreciate that that was a different factual case, but for example, if you look at it as a sort of hierarchy of objections, was it actually relevant or relevant enough? Were answers to credit final? In my submission, they should be, or they should have been extended in the way they were. If they're going to be made at all, should the judge then draw back from making those findings, or at least draw back from making those findings in the terms that he did? That actually leads me on to the judgment itself. And this is perhaps more concentrating on ground 3.
Well, just before we get into the detail, I'm not quite clear at the moment what your position is on what this court's jurisdiction is in respect to these matters. Because they're not in judge's order, as you accept.
Yes.
And so, given the basic principle that appeals are against orders, not judgments, how do we have jurisdiction? And what should we do if we do have jurisdiction?
Yes. The first point is that I accept entirely the appeal is against an order. You can't just say things about what was said in a lower court's judgment. But the second thing is that ground 1 is about the terms of the order. It's about how you construe the agreement.
Yes, but you're pursuing grounds 2 and 3 independently of ground 1.
Yes, but the reason it matters is that if in fact all of this is utterly divorced from the construction point, then it should never have happened at all. And it was a procedural irregularity, because all of this is irrelevant to if you take that view.
Well, suppose you're right about that.
Yes.
What are you asking us to do?
Well, there would be 2 things. The first is to construe ground 1 and to make an order in relation to that.
Yes.
And the second is if you accept that the oral evidence was relevant to the construction exercise, and therefore that the judge was right to embark on hearing to make findings of this nature, and then as part of that, you'd have jurisdiction to say whether those findings were correct or not, and whether, if they're correct, what, if any, effect it has on construction. If they're not correct or shouldn't have been made, then you would simply say so and say, therefore, we disregard them as matters going to construction. That's the way in.
Right. So you're not asking us to... Are you asking us to reverse the judge on questions of fact, which is a very difficult thing to do, as I'm sure you know?
Yes.
You are asking us to say that the judge's findings are not relevant to the question of interpretation, therefore they can, what, be disregarded?
Well, yes, there are 2 points. The lower bar, as it were, is to say if they're irrelevant to the construction issue, then they were matters wrongly taken into account. I mean, presumably the judge thought they were relevant because he deals with them. And he's obviously...
Well, I follow, but I mean, the complaint you make in your skeleton is that Mr. Aymes business activities have been hampered
Yes.
by the judge's findings. Well, what are you asking us to do about that? We may be able to say, well, this is all irrelevant, but then what? There's a judgment, it's out there, it's been handed down, it's available,
Certainly.
no doubt, on the internet or wherever.
Yes. The point is that if, for example, there's a procedural irregularity, questions have been asked which shouldn't, answers have been used to make findings of fact which shouldn't, it's sufficient if there's a judgment of this court identifying the procedural irregularity,
I see.
saying that alone would give grounds for re-examining the construction. By its nature, something's gone wrong at trial in the construction exercise. And in the course of that, of identifying it as an irregularity, the court could then go on to say that there simply wasn't the material available to make the very harsh conclusions, fairly severe conclusions anyway.
Well, that's a different point. That's a completely different point. That would require us to look in some detail at the evidence. See if there was sufficient evidence for the judge to make the findings that he did, some of which were very general. I mean, describing Mr. Aymes as ruthless and manipulative.
Yes.
What are we going to do with that?
Well, the short answer is there are really only three things that you would actually need to look into. It wouldn't be a big inquiry at all. First, you would look at, on this issue of New Ultra and the denial, you would look at Mr. Aymes' answer, but that's short. Secondly, you would look at Mr. Eraut's evidence. Well, he was led into saying yes, basically, and he acquiesced in the question, but he doesn't really give any description. So there's almost no evidence there.
But if, sorry.
You go.
I mean, just suppose that this had actually been an issue, and madly, for whatever reason, there were no evidence before the court other than the evidence we have here. So that the judge knows that there were poison pen things coming from the company. The judge knows that the individual giving evidence in front of him was the sole director and sole shareholder. The judge knows that the poison pen communications were on two different points in time.
Yes.
And on top of that, he has Mr. Eraut saying something. You couldn't say, supposing that it actually were an issue, that it was a finding made by the judge without any basis in evidence, could you? I mean, there would have been some evidence. You say, well, it wasn't a warranted finding because it was irrelevant to the issues and it can't fairly be gone into in circumstances where all the normal processes attaching to fact-finding haven't been followed because you haven't had disclosure, you haven't had witness statements, blah, blah, blah. But you can't say it's an irrational finding in the sense that there is no evidence for it.
I've never actually said that it was irrational. What I have said, and the argument today, is that the evidence doesn't support the strength of the finding which the judge made. And so, for example, if the judge were to have gone through the exercise your lordship suggests, of saying, well, it's a small company and there were two incidents and I can draw an inference and so forth, all that you'd have got in the decision, assuming any of this matters and is relevant, all you would have got is a paragraph which said, I can draw an inference from these various other facts which I find. And for that reason, I don't accept Mr. Aymes, or I prefer the evidence of Mr. Eraut. And if you'd got that finding, I prefer the evidence, and it's plain to a reader that I'm reasoning my way through an inference, then the complaint, as it were, made in the grounds of appeal and the skeleton wouldn't exist, because like many findings of fact, some businessmen will be disappointed when the judge's judgment arrives.
So is it really paragraph 60 that you're complaining about?
Your lordship just bears with me a moment.
The judge says, I find Mr. Aymes to be an unsatisfactory and unreliable witness. He came over as a ruthless and manipulative individual, prepared to colour his evidence to his own advantage. That's the real nub of your objection?
Yes.
And that's what you mean by the strength of the findings?
Yes. Because in my submission, you only have to ask the question rhetorically. What's the basis for saying someone's ruthless and manipulative? It's not the Irish court judgment. That's talking about the company. It's not Mr. Errout. He's led into saying yes, and that's no evidence of ruthlessness and manipulativeness on the part of Mr. Aymes. And the only other bits of evidence, and they are bits, is a little bit of cross-examination by Mr. Bacon about whether Mr. Aymes said in his witness statement, he says he's marketing director of Complan, of Nutricia, the parent company. And there was a question whether he'd exaggerated and was making out that he was the marketing director. And the other point was that he gives a statistic, and I'll take you, if I may, to the witness statement in a moment, where he says, I think Aymes International Ltd has 11.6% of the market.
It's in fact a rather more restrictive market.
It is.
That he says he's talking about.
And Mr. Aymes, in fairness to him, says, well, it can only be the restrictive market. I have 0% of a market I don't compete in. Those didn't even come within a country mile of establishing that someone was ruthless and manipulative. There is no basis for using that sort of, or drawing that conclusion from a non-existent evidence base.
But can you get, I mean, if you take the view the judge took of the New Ultra allegations,
yes,
maybe they would suggest ruthless and manipulative.
But the judge doesn't say that. This is the problem, because if your lordship just bears with me a moment.
But he does say in 61, he agrees with Mr. Bacon that this episode demonstrates a ruthless attitude.
That's it. At paragraph 60, 4 lines in, he says he came over as ruthless manipulative.
Yeah. Well, the judge says at 58 he gave evidence for 4 hours.
Yes. And again, simply saying I've heard him and I think he's ruthless and manipulative, in some cases will be quite enough, because it'll be patently obvious from the nature of the allegations, the way matters are put in the witness statements. And as we all know, some commercial cases can get quite ugly in terms of what everyone's accusing each other of. And there'll be cases where it will surprise nobody that sort of finding has to be made. But in my submission, if you look at what is there in this case, there's the 11.6 statistic, there's the question of whether he was the marketing director or a marketing director, which in my submission are just not in there as contenders for that inference. And therefore, this court is left with either A, you fall back on, well, the judge listened for 4 hours and he's entitled to say that, but nobody else can actually identify what was it in the 4 hours. The respondents aren't here to say.
Well, the judge goes on in 60 to say that he displayed a reluctance to answer direct questions, tendency to deflect awkward questions, supplement the evidence in his witness statement, and so on.
Yes.
Then on the New Ultra point, he says in 61 that his conclusion accords both with Mr. Errout's evidence and with inherent probabilities. Unlikely anybody would have labelled New Ultra without the prior knowledge and approval of the owner and directing mind of the company. And that demonstrates the ruthless attitude to competitors going beyond normal legitimate business dealings. And that's the point. That's all the poison pen stuff, isn't it?
It is. But what your lordship was identifying, that, for example, the judge could have written a judgment with a paragraph which says, in order to make findings on credit, in order to decide who to believe, in order to get my factual matrix correct for the interpretation of the agreement, I regret I have to make the following findings. and then set out that process of inference. And even then, it would only be a process of inference because there is no direct evidence. And all you have is Mr. Erat being walked into the answer yes. But in my submission, even what your lordships identified, those by themselves aren't the basis for that finding of ruthless and manipulative. What appears to be going on is that there's, again, it's the mismatch between the reasoning, what's going on in the background, it's all about New Ultra and so on, which is being magnified to a degree it doesn't deserve, because it only goes to credit, which only matters to factual evidence, which actually has a limited impact on interpretation.
This all brings us back to the question of jurisdiction. So can I test the matter this way? Let's suppose we're against you on ground one.
Yes.
And we say the judge construed the call option agreement correctly.
Yes.
Do you still say that we have jurisdiction to address grounds 2 and 3 on that hypothesis?
You could only say you're against the appellant on ground 1, really on one of, sorry, in deciding ground 1, you would, as part of that, you would have to decide whether the factual evidence of Mr. Aymes and Mr. Erat and so on was actually part of that reasoning. And if you decided that it wasn't, you decide ground 1 against the appellant, and all of this would fall away for the reasons you gave, that you appeal against the order, not the decision. On the other hand, if you say we construe reasonable margin and so on, relevant margin, but we do take into account the evidence that was given from the witnesses, and as a result of that, you would have to grapple with grounds 2 and 3.
This seems paradoxical because it's your submission that this is all irrelevant. So we seem to get into a paradox that it all depends on what the result is on ground 1.
Well, the reason the simple answer to jurisdiction is that if you take the view that you need some oral evidence to establish your factual matrix and so on, then all of this will always have some connection to ground 1, and that will answer the jurisdiction point. If you simply take the view that they're divorced, that it doesn't matter, you can decide ground 1 independently, then my submission would be you'd still end up with a procedural irregularity if you have findings of fact which aren't supported by the evidence base. And I don't mean...
This is where I find this whole ground quite difficult. We're not here to rewrite the judge's judgment.
No.
If there has been a procedural irregularity which leads to substantial injustice, I think is the rubric in 52, then we could set aside something, not quite sure what, because there's nothing in the order. But you did seem to accept a little earlier in your submissions that the judge was entitled to say that he preferred the evidence of Mr. Erat to that of Mr. Aymes, but he was wrong to go on to say that Mr. Aymes was ruthless and manipulative. But we're not, the appeal court doesn't say, well, you used the wrong adjective, trial judge. But that's not our function.
No, it's not. But there are two things. The first would be, if you're construing ground 1 and you take into account any of the factual evidence, then it has some impact on that. If in fact you took the view that there's an irregularity but it hasn't really made much difference to the actual construction issue and so forth, what you'd be left with then would be a judgment which identified it, but at that stage would dismiss the appeal and say, well, there's no appeal against an order because the order wasn't wrong. But what you would have done is identified that the judgment went too far in terms of the conclusions that could properly be drawn.
Well, suppose for argument's sake that we decide that the particular adverse findings which the judge made about exaggeration of his role and market share did not have any bearing on the interpretation of the agreement.
Yes.
And suppose that we then interpreted the agreement in accordance with your submissions.
Yes.
Then what do we do about these findings?
Well, if you decided that the judgment simply had no basis, or not a
No,
proper
I'm
basis.
not saying it had no basis, not least no basis in the evidence. What I'm putting to you is that suppose we say that these particular findings had no bearing on the interpretation of the agreement, which is a different point.
Yes. It would be open to this court, as I understand it, to simply decide ground 1.
Yeah.
And you would decline to deal with grounds 2 and 3 because it didn't affect the order.
Right.
That's as I understand the position. I'm sure your lordship knows rather more about the jurisdiction of the court than I do. What I would say, though, is what I would invite the court to do is that if one court has, in my submission, gone too far in expressing conclusions in a particular way, the root cause of the problem is what's expressed in writing and will be around for a very long time on the internet. It is open to this court, at least in passing, to deal with grounds 2 and 3 in the sense of acknowledge that there was an argument, and for this court to say, for example, that had it been relevant, we would indeed have gone on and decided grounds 2 and 3 in this way.
I understand that. Can you help me on one other thing? What did the court actually do in Re W?
The honest answer is I don't know, but if your lordship can just bear with me.
If you look at the last paragraph of the judgment, what it says, this is paragraph 122, is it says that for those parts of the judge's judgment which record those matters are to be set aside on the basis that they have no further validity and to be regarded as if they've never been made. But,
Yes.
But what does that mean? I mean, how do you set aside a judgment as opposed to an order?
As far as I'm aware, you can't, but if you just bear with me a moment, I just want to see.
Well,
The
I think what Lord Justice McFarlane is saying is that a new version of the judgment, new redacted version of the judgment has to be prepared. That seems to be what he's saying at paragraph 120.
Yes. Yes, that's it. What I was looking for was just the section of counsel's argument or the summary of the procedure in the official reports to see whether, in fact, they were aiming more at perhaps an order, perhaps in family cases where recitals might actually be quite narrative. But it doesn't seem to be that.
No.
Looking at the judgment, there would be 2 ways of dealing with it. The first is, even if you decline to deal with grounds 2 and 3, say you don't need to, it's open to the court, as I understand it, to say, well, if we had to decide it, this is what we'd have done. And we've heard argument on it. And then you have 2 things. There's the lesser course of action, which is simply to leave your judgment there. And that if, for example, businessmen or banks or lenders or whoever looks at these things in future saw the lower court's judgment, they could also be pointed to a published Court of Appeal judgment.
Yeah.
That might be the end of it. Alternatively, what you could do, and it appears that there's jurisdiction here, is to order that the judgment be redacted, although in our case, mercifully, you'd be looking at perhaps a sentence or so.
One thing I see just on that, if you go back to page 123 in the authorities bundle, where the law reporters are setting out what's going on,
Yes.
you see the judgment hadn't yet been handed down. Much easier to redact something before it's been handed down.
Yes, whereas in our case, the judgment, as you yourself pointed out, has been public for a long time.
So you're not asking us to make an order that be removed from the National Archives or anything like that?
No, in fairness, my skeleton doesn't even address this. And it was aimed more at what I described as the lesser of the 2, that there'd be one published judgment of a lower court and a published judgment of a higher court. if the court were minded to go further and make orders for redactions, then perhaps I can say this. One, I do nothing to stand in the way for obvious reasons. And the only thing I should say in fairness is that the respondents won't have been alive to that because it's not in my skeleton. Now, it wouldn't stop you in your tracks, and I'm sure the appellant would be keen to have such a finding, but perhaps I should just add that.
So can you summarise for our assistance what you are asking to this court actually to do on grounds 2 and 3, and on what basis?
Yes. What I'm inviting you to do is consider grounds 1, 2 and 3 together. Having decided what can and can't form part of the factual matrix, because you'll have decided whether a question should have been asked or whether the answer was admissible and so forth.
But it's not binary, because as I think your submissions have acknowledged, it is possible that we will reach the conclusion that the questions that are objected to were irrelevant to interpretation of the agreement, but relevant to credit. So it may be possible to reach a decision on ground 1, which doesn't involve disputed findings because they are not relevant to interpretation, but nevertheless, for the court to say, well, nevertheless, insofar as there were disputes of fact between the parties, these were relevant to credit.
Yeah.
So what does one do on that hypothesis?
If you got to that stage, I suspect you would be in the territory of allowing the appeal on ground 1 and then saying we don't need to decide grounds 2 and 3.
Well, that's realistic on your part, but nevertheless, you're here to represent your clients and to tell us what your clients want us to do, and on what basis.
Yes. Well, essentially, if you got to that stage of you don't need to decide grounds 2 and 3, I would invite the Court of Appeal to actually address, answer the questions in any event, which you do have jurisdiction to do, though you may not need to do it. And having done that, that may be sufficient for my client's purposes, that the lower court having expressed its views in one way, a higher court would then be on record as of expressing its views in the other. And in doing so...
But we don't make pronouncements as to our opinions that aren't material to any order that we make.
As I understand it, though, and what I'm inviting you to do, is to deal with grounds 2 and 3, even if you don't need to. And in doing so, you potentially write in my submission, you do write an injustice that went on in the court below.
And what's the jurisdiction for that?
Well, the jurisdiction is that the court is seized of this appeal, for which permission to appeal was granted. And as a result of that, you've heard the argument, and can then actually give a judgment in response to that.
There is the extra twist that this is an appeal by the company,
Yes,
not by Mr. Aymes.
it is. But if someone wanted to object on that basis, they needed to have done so at the permission to appeal stage, because the argument is before the court. It is seized of it, so there's no jurisdiction point. And being seized of it, you've just heard the argument. So the point is, in my submission, 1, you're way beyond the jurisdiction question. That's permission to appeal. Secondly, as I understand it, yes, you could decline to give any reasons on grounds 2 and 3 on the grounds, strictly speaking, you don't need to. In my submission, that would be such a minimalist approach.
But my lord's question is pertinent, isn't it? Because if you look at Reed W, it was an appeal by those who had been criticised.
Yes.
And they were invoking their convention rights.
Yes.
And it was indeed on that basis that the appeal was allowed. And we don't have that here. And it's not an answer to that to say, well, PTA has been granted, because all that PTA does is deal with the box ticking or whether you can get in front of the court at all. It doesn't answer the question as to whether you have an appeal by the right party. or indeed on a recognised legal basis.
Yes. Well, it is the right party, because of course,
By that you mean the company?
yes, sorry, the company is.
Right, because as you've emphasised, in the course of your submissions, you positively emphasised the fact that the Irish case was involving the company and not Mr. Aymes personally.
Yes.
And yet the criticism is then taken against Mr. Aymes personally. So he is the right. If anybody's convention rights have been infringed, it's Mr. Ames's, not the company's.
Well, the reason it's the company is only the company was party to the litigation in the court below. And of course, as I explain in the grounds of appeal in my skeleton argument, when trouble comes, or when potentially a problem comes, for example, by a future lender or a bank or something.
Yeah, no, you've explained that Mr. Aymes is being personally hampered in his...
Well, this is my point, that as far as we know, because there's no evidence about what else Mr. Aymes does in terms of businesses, this is his company. So it'll be the company that went to the bank or the lender, and it'll be the company that may be refused. So that's why, firstly, the company is the correct appellant and is actually the one likely to suffer for all of this. If what your lordship's getting at is there a remedy for what you might call, in inverted commas, ordinary witnesses, because they may be criticised in a judgment, by itself, as I understand it, the answer is no.
Is that consistent with REW? Because they were ordinary witnesses, weren't they?
They were, and I'm hesitant to say that REW is a family case, so we just box that off and treat it as if it's divorced from everything else. But there was probably an element in that case of ordering, for example, redaction of a draft judgment or an unpublished judgment, where the court had a freedom to act in a family case which it possibly wouldn't have or exercise in a commercial case. Just going back to your lordship's question, what do you do? What the Court of Appeal is invited to do is that if you see in the court below an injustice, I've characterised it as a procedural irregularity for reasons already given, you can take the minimalist approach and shrug and do nothing. And I'd invite you not to do that and pass by on the other side, but rather to deal with it head on in the judgment. It needn't be lengthy.
Yeah.
It needn't, as it were, try to vindicate a reputation where, for example, that's not the problem. It's more a question of simply correcting an example, choosing my words carefully, where the trial judge, in the middle of a very big judgment, may have gone too far too fast, and it's created an injustice for an individual. And there is power to do that, and I'd invite you not to ignore it on the grounds that it's open to you to ignore it, and because the Court of Appeal, in my submission, is there for a lot more than that.
Yeah.
And so, my lords, and that really brings me, if you can just bear with me a moment. Yes, that really brings me to the end of my submissions on those three grounds.
Well, thank you very much, Mr. Lattimer. We're not going to give a decision straight away. So you will get a draft in due course. It's subject to the usual embargo.
Yes, of course.
It says. It'll be your opportunity to correct any English errors, but not to re-argue the case and not to criticise our reasoning. And I think, well, the respondents are playing no part in this appeal, so I'm not going to invite you to try and agree an order, but you better draft an order for our consideration.
Certainly,
in
yes.
the light of whatever it is that we decide.
Certainly, my lord. Thank you.
Well, and send it certainly to Mr. Ketloff for him to comment on, because as I understand it from your as an argument, you'll be seeking costs against him if you're successful, and he's made it plain in his statement that he'll be resisting any such order. So if that continues to be your client's position, then that will need to be addressed at that stage.
Certainly, my lord, yes. I just have one query. You mentioned earlier about the transcript of my objection
Yes, or the judge's ruling on it.
Certainly.
If you can find that page of the transcript,
Yes.
scan it and send it to us by email, that would be much appreciated.
Certainly, my lord. If you could just bear with me a moment. Yes. Does it have the judge's ruling? It does. That's what they mean. Yeah, thank you, my lord. Certainly. What I was just trying to get clear is I think there may be two rulings to send you. There'll be the one about the objection to this line of questioning initially, and then as you saw in the judgment.
There was a credit, the credit ruling.
That's right. So
Well, if there are two, then by all means send us to both,
yeah.
please.
certainly, my lord. But as I understand it, it's the judge's ruling rather than counsel's argument.
No, it's the ruling. It's the ruling on on whatever evidential matters arose, where the judge rules that questions can be asked or evidence can be led.
Yeah, thank you. That's very clear now. If you could just bear with me a moment. I think we'll have to get it. Okay. Yes, I'm told we may not have the transcript of the ruling, but what I've suggested is we may have to get it for you.
All right, well, I think we better see it.
Certainly. The reason I mention it, obviously we can get it expedited.
Yep.
What that means is, of course, what you won't get is an email in the morning.
All right. Well, if I see what you're telling me. In other words, what you're saying is it's not in the existing transcript because it requires judicial approval. So you would have to get the judge to approve it. Is that what you're saying?
Yes, that point hadn't dawned on me. I'd assumed we'd actually got transcripts for everything. But if in fact...
There's probably a gap in the transcript where there's square brackets says ruling on evidence or something,
Yes, and of
that
course
bit
it
hasn't been transcribed
can't
or
be done
hasn't
till-
been sent to the judge.
Certainly, my lords. If that's the case, sorry, it's very clear to me what you're asking for. And if you can just bear with us, because there will be
Do you want to say
time.
something in the meantime?
Yeah, I mean, maybe this, if you don't have transcripts of the rulings for the reasons we've just canvassed, then could you supply a note instead? Do you have notes?
Yes, I think we can. Certainly.
All right. Well, let's have the notes to be getting on with, but I think we would like to see the transcribed rulings in due course.
Certainly, my lord. Thank you. That's clear now what we need to do, and we'll get on with it.
Thank you very much.
Authorize if able.